The impossible just happened, and I don't say that lightly. A federal appeals court, not just any court, but the Second Circuit, arguably one of the most anti-gun, pro-restriction circuits in the entire country, just handed gun owners a victory so massive, so sweeping, so decisive, that it is literally sending shockwaves through the entire legal system, and almost nobody in the mainstream media is giving this the attention it deserves. 45 years. That is how long gun owners in some of the most restrictive states in this country have been living under laws that were never supposed to exist. 45 years of politicians deciding where you can and cannot exercise a constitutional right. 45 years of courts rubber-stamping those decisions and quietly looking the other way. That just ended. The case is Antonyuk versus James, and what the Second Circuit just did in this ruling doesn't tweak gun law, it doesn't adjust it, it doesn't chip away at the edges, it demolishes it. And I'm talking about a framework of restrictions that has been strangling your Second Amendment rights since 1979. If you own a firearm, if you've ever been told you can't bring your gun somewhere that you legally should be allowed to, what I'm about to walk you through changes everything. So before we go any further, over 80% of the people watching right now are not subscribed. We are in the middle of a legal war for your constitutional rights, and this is exactly the kind of information that does not make the evening news. If you want to stay ahead of the curve and know the law before everyone else does, hit that subscribe button and turn on all notifications right now. Let's get into it. To understand why this ruling is such a massive deal, you have to understand the world gun owners have been trapped in for the past 4.5 decades. After the federal courts began applying stricter scrutiny to other constitutional rights in the 1970s and 1980s, gun rights somehow got left behind. Courts developed what was called the interest balancing approach. That's a fancy way of saying, we'll weigh how much the government wants this restriction against how much it burdens your rights. And guess what? The government almost always won that test. If a state said, we think this restriction makes people safer, courts would nod along and uphold it. The government didn't have to prove much, they just had to sound reasonable. And for 45 years, that was enough. Then came the Supreme Court's Bruin decision in 2022, and everything changed. The Supreme Court drew a line in the sand and said no more. They threw out the interest balancing test entirely. They said from now on, if the government wants to restrict your gun rights, they have to prove that restriction is rooted in the historical tradition of this country at the time the Second Amendment was written. You go back to the founding era. You find similar laws. You show your historical receipts. If you can't do that, the restriction dies. Period. That was the earthquake. What just happened in the Second Circuit is the aftershock. And in a lot of ways, it's even more powerful. Here's what led directly to this case. The Supreme Court ruled in Bruin that New York's old proper cause requirement for carry permits was unconstitutional. New York had been making people prove they had a special, individualized reason to carry a firearm in public. The Supreme Court said no, you don't need a special reason to exercise a constitutional right. No more justifying yourself to the government just to carry a gun you're legally allowed to own. New York did not take that gracefully. Instead of accepting the ruling, Governor Kathy Hochul and the state legislature went back to the drawing board and passed the Concealed Carry Improvement Act almost immediately. Think of it like this. Imagine you've been playing a game under a set of rules for 45 years. The referee finally walks out at halftime and says, everything you thought you knew about the boundaries is wrong. The playing field is wider now. You have more room. And then the other team goes behind the referee's back and builds a wall around the entire field while the ref isn't looking. That is exactly what New York did. Their Concealed Carry Improvement Act created a maze so intricate, so suffocating, that even if you had a carry permit, you were living in a legal ghost zone. The moment you left your house, you were surrounded on all sides by restrictions. They created a massive list of sensitive places: parks, playgrounds, libraries, schools, churches, hospitals, theaters, bars, Times Square, public transit, zoos, and on and on. The list was so long it covered almost the entire map of daily life in New York. And then they added what I'm going to call the most outrageous provision in the entire law. They said that every single piece of private property in the state, every shop, every gas station, every office, every business, was a gun-free zone by default, unless the property owner posted an explicit sign saying firearms were welcome. You were effectively a criminal the moment you stepped off the sidewalk, even with a legal permit, unless someone had gone out of their way to give you permission to exercise your constitutional right. Gun owners sued, and the Second Circuit just ruled in their favor in one of the most sweeping, methodically argued opinions we have seen in a Second Amendment case in a generation. Let's be specific about what the court actually struck down, because this is where it gets powerful. The court struck down the blanket ban on carrying in public parks. New York argued that parks are sensitive places because children and families use them. The Second Circuit said that's not enough. You need actual historical evidence that parks were restricted during the founding era, and New York couldn't produce it. People carried firearms in public spaces throughout early American history. You cannot point to a space and call it sensitive just because you feel like it should be. The constitutional test is not about your feelings, it's about history. They struck down the requirement forcing churches to give written permission for carry. New York's law said guns were banned in all places of worship unless the religious leader provided explicit written consent. The Second Circuit said that flips the entire logic of constitutional rights completely on its head. The government doesn't get to make a default decision for a private religious organization. The church decides, the mosque decides, the synagogue decides. Not Albany, not the governor, not the legislature. They struck down the blanket ban on carrying in Times Square and other heavily trafficked areas, ruling that population density alone does not create constitutional authority to ban firearms. There is no historical tradition of gun bans based on how many people happen to be gathered in one location. Crowded has never meant rights-free in American history. And most importantly, they killed the private property default ban. This was the one I described earlier as the most outrageous provision. New York said, unless a business posts a sign welcoming firearms, you must assume guns are prohibited. The Second Circuit dismantled this completely. Think about what that rule actually means when you apply it to any other right in the Constitution. Imagine being required to see a store post a sign before you could speak freely inside it. Imagine needing written permission to practice your religion on private property. That would be constitutionally absurd. The same principle applies with devastating force to the Second Amendment. Your right exists by default. It doesn't disappear until someone chooses to give it back to you. Now pause on that for a moment, because what I just laid out is only half of what this decision actually does. Stay with me, because in a moment I'm going to walk you through something that most channels covering this story are completely overlooking. A part of this ruling that affects not just where you carry, but who gets to carry and under what conditions. And it has implications for every gun owner in this country for the next 20 years. But first, do you think the Second Circuit went far enough, or should they have swung even harder? Drop your answer in the comments right now. I read every single one, and this is the debate we need to be having out loud. And while you're down there, hit the like button. It genuinely helps this information reach the gun owners who need it most. Here is what almost nobody is talking about when they cover this case, and it may be the most consequential piece of the entire ruling. The Second Circuit didn't just strike down specific locations, they also ruled on one of the most intrusive provisions New York buried inside the Concealed Carry Improvement Act. The requirement that permit applicants hand over 3 years of social media history to law enforcement, 3 years of your posts, your political opinions, your private thoughts, your memes, your arguments, all of it handed over to the government as a condition of exercising a constitutional right. New York wanted to scroll through your digital life and judge your moral character before deciding whether you deserved your rights. The Second Circuit struck this down hard. They recognized something critically important. The government cannot force you to surrender your First Amendment rights as a tax to exercise your Second Amendment rights. Your online speech, your political views, your private expression, none of that can be used as a screening mechanism to decide who gets a constitutional right and who doesn't. This isn't just a gun rights win. This is a privacy win. This is a free speech win. And it shuts the door on what was effectively a social credit system that New York was trying to quietly build into its permitting process. Now let's go deeper into the legal engine driving all of these decisions, because this is where the long-term power of this ruling lives. The court applied what's now being called the Bruen-Rahimi standard. The Bruen decision in 2022 established that historical tradition is the only constitutional test. Then the Supreme Court's Rahimi decision in 2024 clarified that the historical comparison doesn't have to be an exact replica. It has to be a genuine analog, a real historical twin in terms of how it burdens the right and why it was imposed. New York tried to exploit that clarification. They went digging through history books looking for anything they could use. They pulled up old laws about reckless discharge, about banning weapons in courthouses, about disarming dangerous individuals, and they tried to stretch those examples to justify banning guns in parks, churches, and private businesses across the entire state. The Second Circuit looked at every single one of those attempts and called foul. You cannot use a law about disarming specific dangerous criminals to justify disarming every law-abiding permit holder at every location you don't like. You cannot use courthouse restrictions to justify park bans. The historical analog has to actually match comparable in scope, comparable in purpose, comparable in the burden it places on the right, and New York could not make those matches hold up. That distinction matters enormously because it means states can no longer go digging for any random old statute and use it as a constitutional shield. The test has real teeth now, and that means every gun law in the country that relies on loose reasoning and vague historical stretches just became significantly more vulnerable. We're not just talking about carry laws. We're talking about storage mandates, registration requirements, restrictions on specific types of firearms. Anything a state is trying to justify with soft historical evidence is now on far shakier ground than it was before this ruling dropped. That is the part of this decision that will echo for decades. Let's make the immediate impact concrete with 3 real scenarios that show exactly how this ruling affects gun owners right now. First scenario. You live in upstate New York. You've had your concealed carry permit for years. Before this ruling, the moment you walked into your local park with your kids, you were potentially committing a criminal offense simply by having your legally owned firearm on your person. That restriction just got struck down. Under Antoniuk, the state cannot maintain a blanket ban on carry in public parks without solid historical justification, and they couldn't provide it. That said, do not assume every park is now fair game without doing your homework first. Some parks sit on federal land and carry separate federal rules. Some border school zones with their own restrictions. Know your specific location. Talk to a local attorney who knows firearms law in your county. The law is still shifting, and you do not want to be the test case. Second scenario. You're a member of your church's security team. Before this ruling, New York was attempting to ban firearms in all houses of worship unless the building employed licensed security guards. The Second Circuit stepped in and said the state has no business telling a pastor, a priest, or a rabbi how to protect their congregation. If you are on a volunteer security team at your place of worship, your hands are no longer tied by state bureaucrats. The church decides its own policy, not Albany, but respect that authority in both directions. If your place of worship puts up a no firearms sign or leadership makes clear they don't want guns on the property, you honor that. This ruling protects your rights and private institution rights simultaneously. The whole point is that the government doesn't get to make this choice. The institution does. Third scenario, you own a small business. Under New York's Concealed Carry Improvement Act, your customers were effectively banned from carrying on your property unless you posted an affirmative sign welcoming firearms. Think about what that actually meant for you as a private property owner. You were required to take an explicit political and legal position just to allow your customers to exercise a constitutional right on your own premises. That's completely backwards, and the Second Circuit said exactly that. Now the presumption defaults to freedom. Your customers can carry unless you specifically and affirmatively prohibit it. The choice belongs to you, not to the state government. Now, before I walk you through what comes next in this legal battle, and I want to be very specific about the moves New York is likely to make and why at least one of them is going to seriously backfire, let me ask you something. Which state do you think files the first major legal challenge to their own sensitive places law using this ruling as the foundation? California, New Jersey, Maryland, Illinois? Drop your guess in the comments. The first state to move is going to set the national tone for how this plays out. New York is not going to accept this quietly. Here's what's coming and what it means for you. The first move is en banc review. New York will almost certainly ask for what's called an en banc hearing. Instead of the 3-judge panel that issued this ruling, the full Second Circuit, all of its active judges, would rehear the case. This is the state's best shot at reversing the decision. But here's the problem. This panel didn't write a passionate opinion. They wrote a meticulous one. They followed the framework the Supreme Court gave them in Bruin step by step. If the full Second Circuit reverses it, they're going to have to explain in writing why following Supreme Court instructions is legally wrong. That is a very hard case to make. The second move is a Supreme Court appeal. If en banc review fails or doesn't happen, New York could try to take this directly to the Supreme Court. But here's the thing. The Supreme Court doesn't have to take the case. And based on what already happened, there's strong reason to believe they won't. After the Second Circuit issued its ruling in late 2024, New York tried to appeal. And in April 2025, the Supreme Court refused to hear it. In the legal world, a denial of certiorari sends a message. By staying silent and allowing this ruling to stand, the Supreme Court effectively signaled that the Second Circuit followed the Bruin and Rahimi standards correctly. This makes the Antoniuk decision the controlling law of the Second Circuit. It's no longer just a temporary injunction or an interesting legal opinion. It is the law of the land in New York, Connecticut, and Vermont. The third move is to try rewriting the law. New York could attempt to craft a narrower version of the Concealed Carry Improvement Act, one that restricts fewer places and provides stronger historical justification for each restriction it keeps. But here's where the trap closes on them. The Second Circuit has raised the bar so high that legislators can't just paste new language over old ideas. Every single restriction has to pass the rigorous historical twin test. And most of what modern gun control legislation relies on has no founding-era equivalent, because it was invented in the 20th century. Every time a state passes a new restriction without that solid historical foundation, it becomes another lawsuit. And that lawsuit now has a detailed blueprint for how to win. Now here's why this matters to you, even if you don't live in New York, Connecticut, or Vermont. California passed its own sensitive places law, AB 1594, that is structurally almost identical to New York's Concealed Carry Improvement Act. So did New Jersey. So did Hawaii. So did Maryland. All of these states created massive sensitive place lists and flipped the default on private property just like New York did. Every single one of those laws is now a target. Lawyers in those states were already preparing challenges before this ruling dropped. Now they have a federal appeals court opinion from the Second Circuit, not exactly known as a conservative, gun-friendly court, that hands them a complete roadmap. They are going to walk into courtrooms in Los Angeles and Trenton, holding Antoniuk like a blueprint and saying, even the liberal Second Circuit agrees this kind of law doesn't pass constitutional muster. What's your excuse? Some judges in those states will follow this precedent, some will try to distinguish it, but the pressure is on in a way it has never been before in the post-Bruen era. The legal momentum is pointed in one direction right now, toward gun owners, and it is not slowing down. Let me shut down 3 myths you're going to see spreading about this ruling, because the pushback is already starting. Myth 1. This ruling means you can carry anywhere with no restrictions. This is completely false and dangerously so. The Second Circuit did not say all restrictions are unconstitutional. They said restrictions have to be historically grounded. Federal buildings, actual courthouses, airports, schools, these still have restrictions, and those restrictions have historical roots that hold up under the Bruen test. There is a deep historical record for those specific limitations. What this case struck down were the fabricated sensitive places that had no genuine historical analog. There is still a legal framework. You still need to know the specific laws in your location. Do not let anyone convince you this is a blanket permission slip. Myth 2. This only matters if you live in New York, Connecticut, or Vermont. Wrong. A major federal appeals court just issued a thorough, rigorous opinion applying the Bruen-Rahimi standard in exhaustive detail. That doesn't stay inside state lines. It travels. Courts and other circuits read these opinions. Lawyers cite them. Judges reference them when building their own reasoning. This is already being cited in cases in the Third Circuit covering New Jersey and the Ninth Circuit covering California. When the first domino falls in New York, the rest of them are headed for the floor. Myth 3. The government can just rewrite the law and fix everything. Not easily. The Bruen test and now Antoniuk have raised the bar to a point where legislators cannot simply paste new language over old ideas. You have to go back to the founding era and find real historical matches for every restriction you want to impose. Most of what modern gun control legislation relies on has no founding era equivalent. Every time a state passes a new restriction without that historical foundation, it becomes another lawsuit with a proven framework for winning. Let me pull everything together with the 3 things you absolutely need to carry away from this ruling. First, the Second Amendment is no longer a second-class right. For decades, courts treated it like an asterisk, technically in the Constitution, but practically optional whenever a government decided it was inconvenient. Bruen started changing that. Antoniuk confirms it in the most powerful terms we have seen from a federal appeals court. Courts are now required to give the Second Amendment the same weight and the same respect they give freedom of speech and freedom of religion. That is a fundamental generational shift in how American law treats your right to bear arms. Second, sensitive places have to actually mean something specific and historically grounded. States have been using that phrase as a blank check for years, slapping it on every space where they wanted to ban guns and hoping courts would go along. The Second Circuit said no more. If you call a place sensitive, you better have historical proof that it was treated as such when the Second Amendment was written and ratified. You cannot use the phrase as a magic eraser. That principle is going to put enormous legal pressure on restriction lists across dozens of states. Third, and most powerfully, the default is freedom, not restriction. The most important thing about this ruling isn't any single decision about any single location. It's the underlying constitutional principle the court applied with full force. Your right exists by default. The burden is on the government to justify taking it away, not on you to justify keeping it. That is how constitutional rights are supposed to work in this country. And for the first time in 45 years, a major federal appeals court is actually enforcing it. This fight is not over. It is never over. There will always be politicians whose first instinct is to limit what you can do, to shrink your rights down until they're small enough to be ignored. What decisions like Antoniuk prove is that those politicians are not the last word. The courts are. And right now, the courts are reading the Constitution the way it was written to be read. That trajectory only continues if you stay informed. If you know what's happening before your state tries to do what New York did, if you support the organizations fighting these battles in courtrooms right now, because cases like this cost millions of dollars, and the people who brought Antoniuk did it so that you have your rights back, if you share this information instead of letting it get buried under whatever is trending tonight. The founders did not write the Second Amendment as a suggestion. It is a right, and a right that people are actually willing to fight for in court and win is a right that lasts. If you made it this far, you are exactly the kind of person who needs to be subscribed. Hit that button. Turn on all notifications. Legal updates on this case are moving fast, and you do not want to be behind. Drop a comment telling me which state you think challenges their gun laws next. Share this with every gun owner you know. This is the information that doesn't get handed to you. You have to go find it. So let's make sure it gets out.